Thanks so much. First slide you will see, we're going to talk a little bit about SESCO, and just as some background, we were founded in 1945, and the reason why we provide this history is certainly we're proud of our long history, but our founder worked in 1944 with the Department of Labor Wage Hour Division. He was an investigator investigating what then were new regulations regarding overtime, minimum wage, child labor. So our history and experience is rooted in wage and hour regulations. Before 1938, there were no such rules or regulations regarding the workplace in terms of minimum wage, overtime, child labor, etc. And in 1938, the Fair Labor Standards Act was passed. The other interesting thing about this history is that you would think that this dragon of compliance requirements would be puff and smoke or maybe 6 feet under, but in actuality not. Wage and hour regulations or non-compliance to wage and hour regulations has been the #1 financial issue or challenge for employers across the country in all industries and in all states. And if you'll change slides, you will see this slide comes directly off the Department of Labor Wage Hour Division website. This is a slide directly off of their site, and it talks about in 2015 the dollar amount collected in back wages and the number of workers, 246 million in back wages for 270,000 workers. This was the #1 violation issue for employers, not EEOC charges, not sex harassment, not discrimination, not OSHA or family medical leave or some of these things, but wage and hour violations, typically overtime not being paid correctly. So the dragon is alive and well, and certainly with the changes this year, we certainly expect more years of concern and liability for employers. Next. This next slide is also off of the Department of Labor website, and what this is telling us is that in 79 or 80% of their investigations, the Department of Labor conducting an investigation within an employer, 8 out of 10 of those, they found some sort of violation. Again, typically it was an overtime violation. And for each employee, the violations added up to about $9,000 per employee. So more than likely, those that are on the call, if you are checked, if you're audited by the Department of Labor, more than likely they're going to find some sort of violation, and that violation is probably going to average about $9,000 per employee. Next. This next slide, again off their website, provides a year-end statistical summary, and most importantly, if you'll look at the bottom line, the concluded cases. So they handled, the Department of Labor that is, and this is federal, this is not state, or this is not lawsuits or otherwise, but the Department of Labor, Federal Department of Labor Wage Hour handled about 28,000 cases. That's an all-time high, and I can imagine that that number will continue to increase. Okay. So we get the question from our clients, from those that call in. One of their questions typically is, well, Bill, we understand what minimum wage is. We think we understand what overtime is. We think we're complying with these rules and regulations. How is it that we get in trouble? How do we get audited? What starts the process? And there's 2 ways that your organization can be audited and possibly be fined or be responsible for back wage liability. The first way, and frankly, we don't wish either way on any employer because it's very stressful, very costly. But the first way, if you're going to get audited, this is the way that we hope, this is the method that we hope that you get audited. And that is typically where there is a disgruntled employee. Maybe it's an employee that we've held accountable for poor performance or attendance. Maybe it's even an employee that we've terminated. And you all have heard it in the past, that employee saying, well, I'm going to call the labor board. Well, and that's what they end up doing. They call the Department of Labor and they make some sort of complaint about their wages. They weren't paid correctly, they didn't get their final paycheck, whatever it might be. And at that point, the call to the Department of Labor doesn't cost them a dime. Further, the investigator on the other end of the line doesn't ask any difficult or hard questions. They make the assumption that what the employee is claiming is true and factual. And then what they will do is either call you or send you a letter, that is you, the employer, and let you know that they're going to come in and conduct an audit. They won't tell you why. They won't tell you who the complainant was, etc. But they will let you know when they're coming in to conduct this audit. Let's say during this process, this audit, the Department of Labor comes in and they review your payroll records and they do find some sort of violation. Again, normally it's overtime, we haven't paid correctly. At that point, they would identify or have us identify all current employees back 2 years, as well as all previous employees back 2 years, and calculate the overtime due, and that's the check that we would write to each one of these employees. We would copy the canceled check to the Department of Labor verifying payment. So normally if the Department of Labor comes in, they will go back 2 years. And that is simply from the date of the investigation. They will roll back 24 months, and any of those employees that are affected or due money, that's how they make that calculation. Now, some of you all may know that the Department of Labor can go back 3 years, and that's normally for what we call a willful violation. The company knowingly and willfully violated the regulations, and that normally is due to maybe the company had been audited previously and maybe fined and or told by the Department of Labor how to comply, and the company simply just said, the heck with the Department of Labor, I'll never get checked again, I'm going to continue to pay in a way that violates the regulations. So at that point, if that's the case, they can go back 3 years. So easy enough. The other and the more costly way, and it's getting more and more popular because of the wages that the employees can collect, is maybe the employee, the current employee or disgruntled employee, maybe the employee that's been terminated, or maybe it's somebody, an employee that has been on the internet, they've read the news about the new regulations, they're simply interested in these new regulations and in how it affects them, and they're curious, and they find, well, you know, I think I'm due some overtime. Maybe my position is due overtime. And at that point, rather than calling the Department of Labor, they call in an attorney. And at that point, the attorney then would conduct their due diligence. They would then start calling other employees that work there, or maybe previous employees, and they work up what they call a class action. Let's say that, again, the employer didn't mean to, just didn't know that they were not complying, and there's some overtime violation. So at this point, through the state court, automatically, the employees are going to be eligible for their 2 years back wage liability, as normally with the Department of Labor. But also there's another automatic 2 years for what they call liquidated damages. So now we're at a total of 4 years, plus you as the employer pay the fees of the attorney fees of the employees that represent the employees. And as you can imagine, attorneys love this because they're not, it's not pro bono, it's not, they're not taking it on contingency or anything else. Whether they win, lose, or draw, they're grinding fees, and it can be rather costly. So that's the route we dread in that, because it can get so expensive. And so those are typically the ways that we would have action, possibly get in trouble, and be required to pay back wage liability. Okay? So what we're going to do, we all know that there's new regulations coming forth in December, on December 1st of this year. But what I want to do at this point, although the Code of Federal Regulations would be several hundred pages long, I kind of want to tell a story here that starts from the beginning and sets the stage for what's going to happen in December, and maybe how we can get ready for these increased regulations. So when you boil it all down, the Fair Labor Standards Act basically requires three things, and that is employees must receive minimum wage for each hour worked, or greater, of course, but federal is $7.25. We've got about 36 callers on this webinar. You probably represent a number of states, and as we all know, a number of states have implemented their own minimum wages. In fact, we have clients in cities such as San Francisco or counties in Maryland or otherwise. Even cities and counties are passing their own minimum wages. But anyway, we're going to talk on a federal level here. So receive at least minimum wage, $7.25, maintain an accurate record of time. That is to verify that we were paying minimum wage and paying overtime correctly. Now, that time record can be by hand, it can be by punch. Of course, nowadays there's lots of electronic means to record time. And employees must receive overtime at time and 1/2 their hourly rate for hours worked in excess of 40 hours per week. Again, that's on a federal basis. There are some states, and I'm sure if you operate in these states, such as California, that requires overtime that when an employee works over 8 hours or on Sunday or holidays, etc. So be aware of any state regulations for overtime purposes. So those are the basic three requirements of the Fair Labor Standards Act. Now, it's our charge as an organization, and your all's charge. What positions can we put on a salary, pay on a salary basis, so that we don't have to worry about maintaining a time record, or more importantly, paying overtime at time and 1/2 the regular rate? And the federal government, Fair Labor Standards Act, has issued what we call white-collar exemptions, that if the position performs the duties as described in these white-collar exemptions and meets the salary requirement. Currently, the salary requirement, minimum salary requirement, is $23,660. Come December 1st, that salary requirement is going to go to $47,476. Now, I'm going to stop right here before we get into these exemptions. Just because you pay someone in your organization $47,476 or greater come December 1st doesn't mean that you don't have to pay overtime. The position has to meet one of these white-collar exemption tests and be paid the salary, and that's the biggest misconception that we have to overcome. So let's look at the next slide. These white-collar exemptions include the executive, administrative, professional, computer, outside sales, and highly compensated. I'm going to cover all of these, but we must know that only a couple, practically speaking, are going to apply to members of this association. So next slide. The first exemption is the easiest but one of the most abused. It's the easiest to apply but one of the most misapplied, if you will, and that's what we call the executive exemption. And in this exemption, the position must be managing 2 or more employees, and the regulations specifically say 2 or more employees, 2 or more full-time. You can look at multiple part-timers to come up with 2 or more full-time. And they must be managing, and this is the key, they must be managing 51% or more of their work cycle. So what does that mean? Hiring, firing, performance reviews, discipline, coaching, counseling, all of those management types of duties. What happens is we have a working manager, working supervisor, maybe somebody that's a manager but also is out in the field, and they're actually performing some type of HVAC or other types of work. If that's the case, then we cannot apply this exemption. So the employee can do some hourly type work some of their time, but not most of their time. And how does the Department of Labor determine this? If the Department of Labor investigator, if they come into your organization, the investigator is going to ask for a private room where they can conduct interviews. You can't be in there, SESCO can't be in there, your attorney can't be in there, and the investigator will ask the employees one-on-one The first question is, what do you do most of your time? Hopefully the answer is, I'm managing, I'm directing, I'm coaching, I'm counseling, I'm hiring, I'm firing, I'm doing all of these managerial types of duties. However, if they answer and say that they're doing other types of non-exempt hourly type work, you're going to lose the exemption. But if we're managing 2 or more, managing most of our time as a primary duty, and we're making the salary requirement, again, it's $23,660 currently, going to $47,476, then you don't have to worry about time records or overtime. Next is the administrative exemption. Administrative exemption, if you Google it, if you read it, you're going to think in your mind, hey, this is a pretty easy exemption to apply. I'm going to apply it to a lot of my office type positions or accounting type positions, and we're going to do, I'm on a webinar. Okay. Administrative exemption. So under this administrative exemption, the position doesn't manage 2 or more employees, but they are in a position of responsibility. They're making decisions on behalf of the company. It's not skill-based, but they're truly making independent decisions. They're not having to maybe go to the owner or otherwise, and or top manager, GM, and they're making decisions. The easiest way to describe this or describe some of the positions that would fall under the administrative exemption. Typically, maybe in a larger organization, maybe a chief financial officer. Maybe they're not managing 2 or more employees, but they're working with the bank. They're managing cash flow. They might be managing investments or 401k. That's the level that we're talking about. What we are not talking about are your accountants, your receptionists, your office managers, your purchasing agents, safety people possibly, low or mid-level HR type person, payroll clerk. All of those types of positions typically are non-exempt and do overtime. So I urge you, and I'll cover, and I'll make this recommendation later on, is that if you're paying anyone on a salary, no overtime, regardless of what you're paying them. I don't care if it's the $23,660 or the $47 or $80 or $90 or $100,000. If you're paying some sort of internal position that's not managing others on a salaried basis, let's talk about it to make sure that in fact they meet the exemption, or you may be assuming liability. And this is one of the most common violations that we see, is that we're paying someone in-house internally. Sure, they're important, sure they're handling maybe confidential information, maybe critical accounting information, but they may not meet one of these, meet the duties as described in the administrative exemption. So be careful with it. Next one. Professional exemption, and we're going to skip through both of these slides, but the professional exemption is strictly reserved for doctors, lawyers, teachers. I go to school, obtain a 4-year degree, many times have to get additional degrees to practice a profession. Just because I have maybe a BS in management or marketing or liberal arts or history or English or any type of 4-year degree, that does not automatically mean that I am exempt under the professional exemption. Again, it's got to be doctor, lawyer, teacher, etc. But again, not going to apply within your all's industry. Next. Next is the computer exemption. As with the administrative exemption, the computer exemption is a very high-level exemption. The position needs to be a programmer or a program analyst. These folks are very high-level .com type folks, Fortune 500 companies. It is not your internal help desk, your network administrator, data entry, folks that maintain the website. All of those kinds of positions are non-exempt, meaning that they're due overtime. So if you have someone that's an in-house computer type guru and you got them on a salary without overtime, again, we may want to talk about it to make sure that the exemption applies or doesn't. Okay? Next is what we call the outside sales. You may certainly have someone in outside sales in this industry. Please note the third bullet point down. If the position is in fact in outside sales and meets the exemption test, there's also no guaranteed salary requirement. You don't have to pay the $23,660 or the $47,476. You could put someone on the outside sales exemption on a straight commission. They don't even have to make minimum wage. You can put them on a commission, a draw against commission, a salary plus, whatever type of pay scheme that you would like. The only stipulation is that they must be engaged in sales, and they must be engaged in sales, outside sales, 51% of their work cycle. This is not an inside sales or a combination inside-outside. So Bill Ford needs to be out in the community making sales with customers 51% or more of my work cycle, 2.5 days or more a week, etc. And if I'm doing that, again, no overtime, no minimum guaranteed salary, no time record. Okay? The next one is what we call the highly compensated. This has been confused. We've done a number of these webinars for a number of industries over the past several weeks, and there's some confusion here. Highly compensated doesn't mean that we have to pay our top managers $134,000 or $4. Again, if a manager, GM, president, if they meet the executive exemption, as we previously talked about, the only minimum guaranteed salary requirement is $47,476. What we're talking about here is maybe we don't have a position, we have a position that does not meet the executive, does not meet the administrative, does not meet the professional or outside sales, and we want to pay them a salary and avoid overtime. Well, we can guarantee them $134,000 and $4, and as long as they're showing some sort of independent discretion and judgment, we don't have to worry about overtime. Okay? All right. So as we just talked, for a position to be paid on a salaried basis and not receive overtime, they have to meet one of these exemptions that we talked about and meet the new salary requirements coming in December, and again that's $47,476. And this slide that you're looking at comes right off the Department of Labor, and they're thinking that there's about 4.2 million workers that fall in between the current $23,660 but make less than the $47,476. And that's how many folks are probably going to be affected in terms of what do we do now? So what do we do now? What's the next slide? You will see this is just a visual in terms of the increase that is coming December 1st, just a confirmation of what we just talked about. You'll also see the weekly 455 currently, 913 come December 1st. Next slide. Now, with this $47,000 requirement coming in December, for the first time in history, we can apply, first time since 1938, first time in history, come December 1st, we can apply up to 10% of a bonus or incentive program against the $47,000. What that means is maybe we have somebody on a salary plus commission, and we can apply, and they're earning some commissions, we can apply up to 10% of that commission against the $47,476. So that means maybe we can pay someone on a guaranteed salary maybe $45,000, $44,000. There's not going to be a lot of wiggle room here, $46,000, and then apply the other 10% to bring us up to the $47,476. Now, you have to monitor that no less than monthly. Quarterly. And if, say, Bill Ford's on a salary plus commission, and my commission doesn't bring me up to the $47,476 as prorated on a quarterly basis, then you have to bring me up. We're not seeing a lot of positions that will be able to take advantage of this much, but there is that possibility. Okay? So the question then becomes, there's lots of small to medium-sized organizations, and I'm talking our client base is roughly 10, 15, 20 employees, up to 1,000 employees or so. Your Fortune 50s, your Fortune 500s are not going to have a problem with this. But your small to medium-sized companies are going to have a problem, and the problem is, let's say that we have someone who is exempt currently. They're meeting one of the white-collar exemptions. Maybe it's a manager, truly managing, and he or she's making over the $23,660. Let's say it's $30,000, maybe it's $35,000, or maybe a little more. But they're going to fall under the new requirement of $47,476 come December. What do we do? Well, what we're recommending at this point are a few things. The first thing that we would recommend is, before you just go out and either change someone's salary and increase it, or you put somebody on an hourly rate with time and a half over 40, or come up with other types of pay plans, first ask yourself, maybe call us, maybe call someone else, research it. But what we want to do is first look at our positions that we're currently being paid on a salaried basis, and before we make any drastic changes, let's make sure that they are in fact exempt. We may find that many of the positions, and this is reality, we find that many of the positions that you're currently paying on a salaried basis, they're due overtime anyway. So I would hate for you to go out and increase these folks to $47,476 and still be exposed to overtime liability that you have to pay because they're not performing one of the white-collar exemption duties tests. So first, do an audit. Let's look at our pay plans and let's see where we are. Number two, the second thing that we recommend is, let's say that we in fact do have our salaried positions. They do meet one of the exemptions, but they're still under the $47,000. What we recommend at this point is, let's keep a time record. Let's have those folks keep a time record. Now, we've got to be careful about asking for a time record, in that we don't want them to think about overtime. We don't want them to think about hours of work, etc., because the hours may not be accurate. Use something like the Affordable Care Act or some sort of benefit, maybe 401k, or you're measuring for requirement under for health insurance, or whatever it might be. Come up with some other reasonable reason, if you will, to maintain a time record. And it can be simply by hand. And do this sooner rather than later. So between now and, let's say, September, October, November, somewhere in there, let's have them keep a time record. And what we may find in the next few weeks or months is that, let's say that Bill Ford's on a salary of $35,000. We can't necessarily maybe afford to get me to the $47,476, but you may find that I'm working only 40 hours anyway. Well, then it's a moot point. Remember, let's go back to our first three requirements: minimum wage and then paying time and a half over 40 if I'm not exempt. So if I'm not working overtime anyway, then it's a non-issue. Maybe we have an accountant that doesn't meet the administrative exemption and they're due overtime, but our accountant works 8 to 5, an hour for lunch, 40 hours a week. You may not want to change pay plans. You may want to just leave as is because there's no liability. Well, let's say the time record comes back and let's say Bill Ford is working 43, 44, 45 hours. Of course, then our challenge is, can we reduce those hours of work? Can we look at our scheduling? Can we look at our staffing? Is there anything that we can do to get those hours of work down, again, to 40, so that we don't have to worry about overtime, time and a half over 40, or moving the person to 47,476? More than likely, you all are already operating lean, mean. You rely on your salaried folks to work extra hours. That's just the life In any small business, any small to medium-sized business, margins are already tight, and so there's probably not a lot that you can do based on what I just stated. But still, for your peace of mind, let's just get a feel for what the hours of work are and what are required. Let's say that in the end, bill forward is at $35,000. I'm a manager. I meet one of the exemptions. Maybe I meet the executive exemption as a manager, and I'm working 45, 50, 55 hours. So you have options at this point. The options are limited, but here are your options. The first I don't recommend, and that is do nothing. I have audited clients for 28 years, and year after year, clients will tell me, well, Bill, I understand what you're saying, but I want to pay this person on a salaried basis, and I don't want to pay them overtime. I'm going to roll the dice. If I get caught, I'll worry about it then, but hopefully I won't get caught. With the news media, with how much attention this piece of legislation is getting, I would be concerned because your employees are out there on the internet, they're reading the paper, they're watching the news, and if they haven't already, they're probably going to be asking questions. So be very careful about doing nothing. The next, and if you'll go to the next slide, the next option is increase the salary. Bill Ford, again, is making $35,000. And remember, to be exempt, I got to make the $47,476 come December. Well, the government just thinks you can go out there and increase the salary. Maybe some of you all can. Maybe you can increase me to the $47,476, and therefore I'm exempt and you don't have to worry about overtime. That's what's so frustrating to me, just as a side note, is that the government doesn't understand, or they don't care. It could be both, but the government doesn't understand that our labor cost in any business, no matter how large or small, but particularly small to medium-sized employers, our labor cost are our largest single controllable cost, meaning that when we're in business, rent, our lease, equipment that we buy, the paper for the copy machine, the lease on the copier, our phone system, our internet, whatever the cost is, someone is telling us how much we're going to pay for that service or for that product. Sure, we can negotiate a little bit at times, but somebody else is telling us how much we're going to pay for certain things, those expenses. However, we get to decide as an owner how many people we're going to hire, what we're going to pay them, what our pay scheme is going to be, maybe what our benefits are going to be, what our fringe benefits, are we going to offer a 401k, or we're going to match it. So truly our labor costs are in our control, and many times labor costs are upwards of 40 to maybe even 50 cents out of every dollar that is spent. So it's a significant cost, and it is in our control. Well, the government just thinks we can go out there and change someone who's being paid $35,000 to $47,000, and it's just not going to happen in most cases. So if we can't get me to $47,476, then you're going to have to pay me overtime if you want to comply with the law. And one option is an hourly rate with time and a half over 40. Easy answer, but that's not always the best answer. Let's take me for an example. Bill Ford's been on a salary, $35,000, and maybe I've been on this salary for a number of years. Well, I budgeted my life around this salary. My expenses, my family, my home is budgeted around this salary. And now you're going to put me on an hourly rate, which in my mind, now there's nothing guaranteed, and my earnings are at risk. And it's a real shock to the employee, and it can be concerning. But that's certainly an option, an hourly rate with overtime. Now let's go back to the time record process. Remember we talked about maybe it's a good time to keep some time records to get a feel for the actual hours worked. Maybe you decide to put Bill Ford, who can't be paid the $47,476, and now I'm due overtime. Maybe you decide to put me on an hourly rate with overtime, time and a half over 40. At least now, come December 1st, you have some sort of benchmark, meaning a time record so that you can kind of monitor and keep my overtime hours in check. If you don't have that, and come December, you better believe I'm going to work as much overtime as I possibly can. So that time record between now and December may help you control excessive working hours. Now, there's one other option versus an hourly rate with overtime. It is a non-exempt pay plan, but it's what we call the fluctuating work week method of payment. Look at the next slide, please. So it's a fancy term, and I'm going to walk through this because it can be confusing, and this is one of the negative portions about the fluctuating work week, in that it can be confusing. But basically what we're saying here, or the government allows, is that you can put someone on a guaranteed salary for all hours worked. Now, that needs to be discussed a little bit. And this is what the government is saying, is that if you put me on a guaranteed salary, it must be a salary for all hours worked in each work week. So the negative for the employer here, if you're thinking about this, one negative thing here for you is if Bill Ford comes in and works a half a day Monday, and then I'm out sick the rest of the week, and let's say that I'm out of vacation or sick leave or paid time off or whatever it might be, you still, as the employer, have to pay me that guaranteed salary if I worked any part of that work week, okay? The positive for you as the employer is that if I work 50, 55, 60, it's still the same salary. So it's a guaranteed salary for all hours worked. Now your obligation for the halftime portion, for overtime is halftime. So for any hours worked over 40, you have to pay halftime. And the advantage to you as the employer is that it's not time and a half, the rate of pay. It's not time and a half or 150%, but halftime or 50%. Because again, we've already paid straight time for all hours worked in this guaranteed salary. So for an example, we have a weekly salary. Let's say that Bill Ford is at $35,000. You can't get me to the 47. Neither one of us want to put me on an hourly rate and start tracking time. Let's just say you take that $35,000 salary and you convert it to a weekly salary. That might be one way you go. By the way, under the fluctuating work week, there's no minimum guaranteed salary requirement. All I have to do is make minimum wage for each hour worked. So the salary divided by hours worked just simply needs to yield minimum wage. So anyway, we come up with a weekly salary for me of $600. And let's say for a given work week, I work 45 hours. So you divide the total hours worked into the salary, and you come up with an hourly rate of $13.33. And instead of time and a half of that, you take halftime, which is $6.67. So $6.67 times the overtime hours, or 5 hours, your overtime due is $33.35 for that week. Now, the next week, I may work 43. The next week, I may work 46. So whatever hours I work in that work week, that's what you divide into the 600. Now, a couple of things here to think about. If you use it, we probably ought to talk offline. And by the way, what we've committed to members for PHCC is that if you have questions following this webinar, of course we're going to take Q&A at the end, but if we get into some technical questions that you'd rather talk one-on-one with us, you can call us or email me, and I'll call you back and we'll talk about it, no charge. If you're thinking about using this pay plan, I suggest we talk a little bit, again, no charge, not so much about how it works, but how we're going to communicate it to employees, because I'm sure you all that are on this call are already thinking, well, this is kind of a tricky way to do this. You're cheating the employee out of something here. You're only paying them halftime. Well, it can be win-win. Rather than, Mr. Employee, I'm going to put you on an hourly rate, and if you work 20 hours, that's what you get, 20 hours times your hourly rate. Listen, rather than you've been on a salary, rather than put you on an hourly rate, we're just going to continue a salaried basis, and that way you know what you're going to make week in and week out. That's a very positive thing for employees, and you all as alike, in that you're able to budget much easier in terms of your labor cost. As to the halftime payment, you simply let the employee know that this is a technical payment required by the government. You're still going to make your $35,000 a year and maybe plus additional halftime. So it's in how we communicate it and how we keep them focused on annual earnings. Because the more hours they work, for example, if you take this example that you have on your slide and you divide it by 55, that 1333 is going to drop. It's going to get smaller, and that 667 is going to be smaller. And such as the overtime due, it's going to be smaller. It might be $28 or $29 versus 33. So the more hours they work on this, the less they make. Again, it's a technical payment. They got to remember they're being paid on a guaranteed salary basis, and it's much better than an hourly rate with time and a half. So that's an option. A couple of things under the fluctuating work week. The government, the Department of Labor, does require that the hours fluctuate. Now, it doesn't have to be week in and week out, but that we need to fluctuate. Because if, and I'm sure a lot of you all are on this call already thinking, well, I could put 45 hours, I could guarantee somebody 45 hours, and I would be guaranteeing them $633.35 week in and week out. The government doesn't like to see that. They want to see the hours fluctuate, okay? So 33, 38, 40, 45, 46, whatever it is. And then the other thing is we must sit down with the employee. They don't have to agree to it, but they need to understand it, and we need to show the government that we did explain how the pay plan works. Okay? So it can be a great program. We're seeing it a lot in different industries, and again, if you're interested in it, we again may want to talk offline to make sure that we communicate it and implement it properly. Okay, next slide. Next slide. So I got to go back to when I started before we discussed the white-collar exemptions. Again, the myth is if I pay someone on a salaried basis, I don't have to pay them overtime. Even if I pay them $47,476, I don't have to pay overtime. That is not correct. You have to meet the exemption status and the job duties as well as the guaranteed salary requirements. Next. Now, let's say that we do have someone on a salaried pay plan. They do meet one of the exemption requirements, executive, administrative, whatever it might be, and they meet the $47,476 or greater. We're paying them the guaranteed salaries required. Sometimes we'll get the question from our clients, well, do I always have to guarantee that weekly salary for these folks? And the answer is no. We can deduct from that guaranteed salary, unlike, I got to be cautious here, unlike the fluctuating work week. Again, we can't deduct for partial time worked under the fluctuating work week for each work week, but we can under an exempt salaried pay plan. And the reasons are, you'll see two slides here. That one is one day or more for personal reasons. So let's say that I go to the owner, president, GM, whatever, and I say, look, I need a day off to move. I want to take it unpaid, and we may agree to do that. One day or more after exhausting paid time off. Let's say that you all have a benefit of 2 weeks of vacation. Let's say that I have used all of my vacation, and then I'm out sick, and I've got no other time. I've got no sick leave. I've got no vacation. You can, at that point, deduct in full day increments. You can offset jury or military pay, penalties for safety infractions. It might be, we're doing, next slide, disciplinary leave. Let's say maybe there's theft or sex harassment or customer service problem. Maybe you send somebody home that's on an exempt salaried pay plan. Maybe you send them home on an unpaid suspension. You could do that. If you have 50 or more employees and you're complying with family medical leave, you can deduct in partial days and then beginning and ending weeks. But those are the times that you can deduct from the guaranteed salary for those exempt folks. Next. Okay, so what we've been talking about are salaried positions, hopefully exempt, meaning that they perform the duties under the white-collar exemptions, executive, administrative, etc., and they meet the guaranteed salary, $47,476. Now, we talked about optional pay plans earlier. If you have non-exempt employees, meaning that they don't meet the exemption or the salary, and you can't get them there, there is another optional pay plan, and I waited till the end to discuss this because it can be very complicated. Let's say that we don't want to use or implement an hourly with time and a half, or a salaried with half-time or either fluctuating work week. There is one other special exemption that many of you all may be familiar with, and it's available to any organization that is considered retail. Maybe it's your local corner automotive service shop that's retail. Maybe it's your mattress corner sells mattress shop who's selling mattresses or furniture. If you're considered retail, meaning that 75% or more of your gross revenue comes from the ultimate consumer in the form of a repair or service, not construction or wholesale. I got to be careful here. Not construction type work or wholesale type work, but it's a repair or service. If you're getting 75% or more of your revenue from a repair or service, then you're considered retail. So why is that important? Well, if you're considered retail, you can put an employee on what we call the Retail Sales 7I exemption. And that is where we put an employee on an incentive, true incentive commission program, meaning that an employee is on some type of incentive program based upon the service that they're providing and how much maybe a customer pays. So rather than an hourly rate with overtime, maybe we pay someone on a percentage for the service that the customer paid for. Or maybe you come up with a scheme that says a certain repair pays an hour and a half. However, if Bill Ford does it in an hour and does a good job, I still get paid the hour and a half. So it's an incentive program where I'm earning commissions based on my production. And there's two things. If I average, I don't have to make $10.88 per hour, but if I average $10.88 per hour, meaning that you look at my earnings at the end of the work week, you look at maybe all my commissions earnings at the end of the work week divided by the hours worked, I have to make at least $10.88 per hour or more. That's on a federal basis. Now again, if you have a state minimum wage, we have to make that times and a half the minimum wage for that particular state. But at least on a federal basis, if you don't have folks out in the field on a production basis making $10.88 per hour, you probably don't want them anyway. They're probably not going to last very long. And then the other requirement is they have to make 51% or more of their gross income from commissions. So meaning I could be on an incentive program, but I don't have to make 100% in commissions. I may have a salary plus incentives. I may have an hourly rate plus incentives. As long as the greater portion of my income comes from commissions. So this is viable. We see it in the group that we work with, QSC. We see it in that group. We see it in a lot of other types of similar types of organizations. So mostly for your technicians, your folks that go out into the field that are on some sort of production, we might be able to apply this. And the only requirement here, again, is they average at least $10.88 per hour. And you look at that weekly. And 51% or more of their gross incomes come from commission. Now, the way you look at that is you don't have to look at it weekly, but you can look at it monthly, no less than monthly, but monthly all the way up to 12 months. You just need to determine and articulate when you're going to check it. You may check it monthly, you may check it quarterly. If you're seasonal, you may want to look at it at the end of the year. So that's totally up to you. And you just look at my total earnings at whatever point in time you're going to measure. You look at my total earnings and you look at what I've made from a commission or incentive program and what I've made from an hourly or salaried basis, and I just need to make 51% or more from the commission. And if that is the case, then you don't have to worry about overtime. You do have to keep a time record to prove these things, but you don't have to worry about overtime. So again, I know that's confusing, but it might be something that we'll want to talk about. If you have folks on an incentive program, and we can discuss whether or not it's compliant or how you can make that compliant. Okay? So what we're going to do now is we're going to walk through common violations based on our auditing practice. We go out and we conduct these wage hour audits, and we're going to work through this pretty quickly because we're getting towards the end. But these are just some tips, suggestions. Be careful of certain things that we find. The first common violation or trap based on our auditing work is our client or an employer is paying someone on a salaried basis, but they don't meet one of the exemptions. Most common is a manager who's really performing hourly or non-exempt work as a primary duty, or administrative employees, as we previously talked about, who are not exempt, meaning they don't meet the administrative exemption, office managers, accountants, maybe inside marketing people, IT techs, etc. So again, our suggestion is if you have anybody on a salaried basis that you're not paying overtime, let's talk about those before you move forward with anything else. Number two, employees cannot waive their rights. And I literally had this a couple of weeks ago where I was talking, working with an employer on site. We were working through this very same challenge. He's got two employees. They're paid in the $70,000 range. They're non-exempt. They don't meet the executive, administrative, etc. So thus, they're due overtime. They work a lot of hours. So we went to them and we talked to them, and they said, well, you know what we would like to do? We would like to sign a waiver. We would like to sign a contract or an agreement. We like our $70,000 salary. We don't want to go on the clock. We don't want to be punching a clock, receiving an hourly rate with time and F over 40. Let's just continue the way we're doing it. Well, of course, the answer was we can't do that. Employees can't waive their rights. So let's say that the employees agree to that $70,000 salary and they're still due overtime, and we don't pay it. Let's say the Department of Labor comes in and they investigate, and they find out that these two employees are due overtime. Even if those employees, and I've had this case literally, even if those employees look at that Department of Labor investigator and say, look, we don't want the overtime. We like the way we're paid. We don't want to change. Don't make us change. The Department of Labor investigator is going to say, look, you either take the overtime due back 2 years, or we're going to put it in the Treasury, your choice. So again, employees cannot, even though it's to their benefit, they may not, they can't waive their rights. Number three, be careful about what are hours worked. The first most important thing is monitor and edit your time records. Even in this day of electronic time records that goes directly into your payroll system, I urge you to review those time records at the end of the week, or at least at the end of the pay period before you pay someone, and look for these things. The first most common violation is where, let's say Bill Ford comes to the owner and says, look, I'm going to clock out at lunch, 12 o'clock as normal, but I want to take a short lunch. I'm going to clock back in at 12:15. I just want to take a 15-minute lunch because I want to leave early at the end of the day. I want to go to my son's baseball game, whatever it is. And the owner says, sure. If the Department of Labor comes in and they see my time record where I've clocked in and out for 15 minutes, they're going to say that you got to go back and pay that period of time. Said differently, for any period of time to be unpaid, it has to be 30 minutes or longer. So monitor any kind of short clock in and out and make sure that that's paid. So if I run out and I'm taking a smoke break and I'm in and out for 5 minutes and I clock in and out for 5 minutes, you got to pay me. If I take a short lunch of 10 or 15 or 20 minutes, and even though I've clocked it, you got to pay the full time. So for any period of time to be unpaid, it has to be 30 minutes or longer. Be careful about your travel time, particularly folks that are traveling from home to home or service job to service job. Travel time is actually working time. You got to pay me for meetings and training time. Next. As I just said, if I'm working through lunch, you got to pay. Pre-work. Let's say that I come to work. I'm one of those good employees and I come to work. I don't clock in because you told me not to clock in before 8, but I'm out on my truck. I'm getting ready for the day. I'm getting my tools ready. Technically speaking, that is paid time, so be careful about folks coming in and working off the clock. Of course, homework on the computer, cell phones, etc., that can be paid. So not calculating the regular rate properly, the next issue, number 4 here, you can't average work weeks, meaning if you pay every 2 weeks and bill for it is due overtime and I work 35 hours one week and I work 45 hours the next, sure, I've got 80 in for the two weeks, but I'm still due the 5 hours. There's no such thing as comp time, meaning that if I work overtime, you can't give me time off at a later date. You have to pay me. Next. Be careful about any kind of pay deduction, particularly if an employee quits and they haven't turned in uniforms or some sort of tools, equipment, or supplies. Be very careful about holding final paychecks. And then the last one here, number 6, is be careful about paying someone as an independent contractor. You folks are the independent contractors, but if you pay someone, an individual, on an independent contractor basis and issue a 1099, the IRS are checking those. And to be a true independent contractor, to issue a 1099, that person, that organization, they need to be in business. They need to be advertising. They need to be performing work for other than you. They need to be invoicing. They need to have workers' comp, business license, etc. So be very careful about paying somebody as an independent contractor. Okay. So with that, we're toward the end. Let's go ahead, Mike, and if you want to open up for questions.
Yeah, sure. We actually have a question lined up here. If you can answer it real quickly. Thoughts
Sure.
on how payment of an exempt employee is paid while on 2-week military leave? Are we required to pay them their weekly salary while they are out, PTO to be used, or just sit the pay they receive for military training?
There you go. And you can actually, yeah, you can offset the salary against that military training. So whoever has that may want to call me separately, and I'll explain that in more detail. But they could, if they wanted to, take PTO. It's up to your policy. There's several options here, but it's not necessarily required that you pay them for those 2 weeks while they're out.